Welcome to the course of Public International Law. I'm Cedric Rijkaard. I'm Professor of Public International Law at this university. Let me first say a few things about our pedagogical approach. This course is taught entirely in English, and this is in line with the policy of the law school to offer some courses in English. And what better course to offer in English than Public International Law? There's something else that is rather special about this course, and it's the fact that we do not offer lectures as such. So you don't go to a large lecture hall where you will listen to the lecturer speaking in front of 500 or 600 students. We don't have that, and we replace that with something else, namely knowledge clips. So we have recorded about 35 knowledge clips relating to various topics of public international law. And from this year onwards, we also offer a special digital platform where you can ask any questions you may have relating to the textbook of international law, which we will use, and we will give answers, digital answers, so it's really an online environment. And you can ask questions from day one onwards through the very last day of the course, and we promise to get back as soon as possible to you within 24 hours during weekdays. Obviously, we also offer seminars, and we offer Moot Court, and Dr. Otto Spijkers, who's in fact right now sitting next to me, will take the floor in just a few minutes to explain the details of the Moot Court. During the seminars, we will pay ample attention to what is in the news regarding public international law, really to drive home the message that international is important in the regulation of international affairs, and also that it is important for you, that it has an impact on your daily lives. International law might sometimes create the impression with students that it is a bit messy, and this is partly related to the fact that international law is not always properly complied with. But it's also because we don't have an overarching code. Like in private law, you have the Dutch civil code where you will typically find the answer to the thing that you're looking for, but in international law we have different sources and we have different materials. But it is our aim to structure all those materials to you and to give a basic introduction to the principles of public international law. Let me now give you an overview of what we will deal with on a weekly basis. Now, for very practical information, I refer to the syllabus, to the manual, which you will find on Blackboard, and obviously on Blackboard you find all information that is relevant for this course. So I will limit myself to a more substantive overview regarding the topics that we will address in an 8-week period, which of course culminates in an exam at the end of this course. And I will also try to highlight the interrelationships between the various topics that are addressed in those 8 weeks. We will start with a discussion of the nature of international law in week 1, and we will highlight that international law is different from national law, although international law can have an impact on national law, can have effect in the domestic legal order, as you may possibly have already learned in your courses on Dutch public law and constitutional law. In week 2, we will deal with the sources of public international law, and there we will also highlight the fact that the sources of public international law are different from the sources of national law. And you will learn there that we have treaties and we have customary international law as the main formal sources of public international law. In week 3, we will deal with the subjects of international law, and again, the subjects of international law are different from the subjects of national law, and the main subjects of international law are states, although we will also learn that throughout the 20th century also other actors have been recognized as subjects of public international law. In week 4, we will deal with jurisdiction and immunities, and jurisdiction closely relates to the question of statehood, which will have been addressed by week 3, because states have sovereignty, which means that they have jurisdiction over events that happen on their territory. This is territorial jurisdiction. We will also learn that in some instances there is a possibility of exercising extraterritorial jurisdiction. We will also learn that sometimes states have jurisdiction, but then there is an obstacle, there is an immunity. For instance, you cannot exercise jurisdiction over states or diplomats or other actors of foreign states because they enjoy an immunity from jurisdiction, and then the case cannot move forward. In week 5, we will deal with the settlement of disputes. Now, if in the past states had a dispute with each other, then they might have gone to war. But these days, they have to go to court to fight their disputes, and a court of law will in the end settle the dispute. We will give an overview of the various mechanisms of dispute settlement in international law and pay ample attention to the International Court of Justice in The Hague. And this ties in very well with the Moot Court, which we will organize, in which you will deal with a case before the International Court of Justice. In week 6, we will deal with issues of responsibility, mainly state responsibility. You will learn that states have all sorts of obligations in their international law on the basis of treaties, on the basis of customary international law, and then the question arises under what circumstances the responsibility of the state could be engaged and what are the consequences of a finding of state responsibility. In week 7 and 8, we will deal with some specialized fields of international law. There are many specialized fields of international law. Think about international humanitarian law, international criminal law, space law, air law, migration law. But we've opted to choose 2 topics for further discussion: peace and security, regarding the use of force, under what circumstances can states use force against each other or to address security threats. And in week 8, we will deal with environmental law, international environmental law, and with the law of the sea, the law governing the oceans. We hope you will learn a lot from this, and that you will be able to connect the theory, the knowledge that you will gain to actual practices of international law, which you will see in the news. Thank you, and looking forward to meeting you.
I will say a few things about the Moot Court trajectory, which will run parallel with the more traditional teaching that we also offer in this course. So what are we going to do in the Moot Court trajectory? Basically, the aim is to prepare you to plead a case, for example, before the International Court of Justice. So pleading means arguing your case before a court of law, as these distinguished people are doing that you now see on the slides. Besides preparing you for the conduct of oral pleadings, for the delivery of oral pleadings, we will also practice the writing of a memorial and of a judgment. So first we will prepare you to do oral pleadings. Here you see some students that are practicing before a Moot Court of Law. The written part of the Moot Court trajectory consists in the drafting of a memorial or of a judgment. So some of you will write a memorial, some of you will write a judgment. If you write a memorial, you will do this with a few of your fellow students as a group. Then you have to plead the case of your client, so you have to be subjective. If you write a judgment, you have to come to a conclusion based on a careful and objective weighing of the different arguments of both applicant and respondent counsel. So there you have to come to an objective conclusion based on objective arguments. This is a bit different from what you are used to doing in university, and that is the writing of academic articles or papers. And so the characteristics of a memorial or a judgment is very different when compared to more scholarly work. And in the Moot Court trajectory, we will train you and we will make you aware of this difference. We will also teach you how to argue your case persuasively, be it in written or in oral version. So we will teach you the Iraq method. First, we want you to introduce the issue, the problématique. Then we want you to identify the relevant rules of international law, be it treaty or customary law. And then we want you to apply those rules to the specifics of the case and develop your argumentation, after which you will reach a conclusion. That is, we call the IRAC method, issue, rule, argumentation, conclusion. Some of you will be judge, so there's a very particular role for you. You basically have to interrupt your colleagues with questions. Those that are pleading the case, you have to interrupt them with questions, so to test their knowledge and also to test their nerves when appearing before court. One of you may be appointed registrar, and this person will be responsible for keeping of time and for the fair and good conduct of the proceedings. So briefly, now on the slide, briefly you will see the schedule and how these oral pleadings are set up. So first the applicants will plead, then the respondents will plead, then there is room for the applicants to respond to the argumentation of the respondents. We call that the rebuttal, and then the respondent team has the final word in their rebuttal, and then the court will deliver its judgment. So that is, in a nutshell, the moot court trajectory of the course of public international law. Thank you for your kind attention.